This is a non-profit video. It's not sanctioned by Workforce Development or the state of Iowa. It's from all volunteer time. And this is legal information, not legal advice. Now, what I want to talk about in this video is the appeal notice. And here's what an appeal notice looks like for a telephone hearing currently in October of 2011. And it will change. And there are multiple notices. There's a different type of a notice for telephone hearings and for in-person hearings. And as technology changes, there'll be different methods of participating in these hearings. I anticipate that instead of calling in a phone number and then having us call, having the Appeals Bureau call, you will end up calling an 800 number at the time the hearing is to start. First of all, let's take a quick look at this. The step in the process we're at is an appeal hearing. So the claimant would have filed for unemployment, received a green sheet or monetary record. Then the employer would have been sent a protest. The employer would have the right to protest, and if they did, and a fact-finding interview was probably conducted. Sometimes these decisions come out without fact-finding interviews because there is one issue. In this particular case, you can see there was 2 names and addresses on the hearing notice, one for an employer, one for a claimant. Sometimes there are one-party cases where just the claimant or just the employer is involved, and that would only have one note or one name on it. So the first thing you should do is take a look and see who the other side is, and see which employer it is, if there is an employer, and what the issues are. And you can see here there's code sections for what the issues are. This one shows 9662, which is a timeliness issue. 96528, which is a misconduct issue, a discharge issue, firing, and 96551, a quit. We drop down and you can see in bold letters there are instructions. Immediately call when you receive this notice. And it just shows the date and time. Now, the major mistake, the biggest mistake that's generally seen is that people get the notice and they're in a hurry, so they look at the date and time and they don't read the instructions. If you read these instructions, and each notice will have a different set of instructions. This one is quite clear in its warning. The judge will not call you on the day of hearing if you have not called. And so the bottom line is there are multiple notices. They're going to change. You must read these notices from top to bottom so you know where you stand and what you need to do. If you don't follow the instructions on the notice, you'll lose the opportunity to participate. And let's move on down. Take a look at the bottom, and at the bottom it says, gives a narrative of what the issues are, whether the appeal is timely, whether the claimant was discharged for misconduct, that means getting fired, whether the claimant voluntarily left for good cause attributable to the employer. And so it gives you a lot of good information, tells you what the hearing's about and what's going to go on. And then what you need to do, after you've taken a look at that, you flip the notice over and read the back side. And I would say this is the least read document of all workforce development documents, yet has the most information, most valuable information that you could want. First of all, it indicates that this is hearing information, that these are public hearings. Anyone can come and listen in, watch, and that can obtain information from these, and often news media request copies of the hearing record. There are some circumstances where the records can be sealed for confidentiality reasons that are required by statute. I won't get into those, but there is possibility to that for private matters. Nevertheless, public record means public record. Anybody can have them, and it might show up in a newspaper if it's a juicy story. Participation in the hearing, it's quite clear that you need to follow the instructions in the hearing notice, or you won't get to participate. And because there are so many different ways that you can have a hearing, there can be an in-person, a telephone, and the method and procedure does change. All I can say is read the instructions carefully. If you fail to read and follow the instructions, you may very well lose out on your chance to participate. The next section concerns evidence. If you have documents, send them immediately. If the documents don't arrive in time, if the documents don't make it to the Appeals Bureau in time to get them sent to the other side, they may not be admissible. And you'll be stuck either giving a narrative of the documents or reading pertinent portions into the record. It's certainly a lot easier to conduct a hearing when the documents are there. And the fact-finding interview should have given you a tip as to what you need. One of the common problems is that the best example is call-ins for absenteeism. We get a lot of absenteeism cases, and when there are call-ins on absenteeism, claimants will often say, well, I did call in, I have a record on my cell phone. That happens at fact-finding. Then you get to the appeal hearing before an administrative law judge, and there is still no record of those call-ins, no hard copy record from the telephone company showing when those calls are made, even though it's probably accessible. So think about what documents you need. Get those documents and send them in a timely manner. And if you're a little late on sending them in, send a copy to the other side. It's permissible to send a copy to the other side rather than expect the appeals bureau to do it for you. So for example, if you're an employer and you have documents that you need to get in and you only have 5 days left, you aren't going to be able to get them to the appeals bureau and then the appeals bureau get them to the claimant in time, go ahead and mail a copy direct to the claimant's address and write on your cover letter, a complete copy has been sent to claimant at the last known address. You could even put the address down on your letter. Same goes for claimant. You can do the same thing. Send them to the employer. Now, if there was a fact-finding hearing, and most of these unemployment appeals have had a fact-finding interview in advance, those documents that were submitted at fact-finding at the prior hearing, people will call it a hearing, but it's actually called a fact-finding interview because it's not a due process hearing. Those documents are not automatically transferred to the appeals bureau. They aren't there. If you want them, you must call or write and ask that they be transferred and that you receive a copy. The appeals bureau will then retrieve the documents, send them out to both sides, and have them available for admission at the time of the appeal hearing. And subpoenas, we do have a right, subpoena power, and you can subpoena witnesses. Be very cautious about using subpoena power. If you want a subpoena, you need to say why the witness or documents are important to your case. You need to establish relevance and show that the witness refused to testify or the opposing party refuses to give you the documents that you want voluntarily. Also, you must have a complete name and address. Don't send documents in for a subpoena that says, please subpoena John Doe, he still works for Acme. It just isn't enough information. You need to have contact information. Now, before subpoenaing documents and calling witnesses, both parties need to think real hard about who they want as a witness. And the reason that you need to think hard about this is that when in a private phone call to a potential witness, people will often tell you what you want to hear. But when they are under oath, and for example, a witness who is still an employee of the employer, and they may very well be sitting across the table on a conference call, sitting across the table from their supervisor or the company owner, may be a different thing. So any claimants who have potential witnesses they're considering subpoenaing, you need to know what they're going to say before you send out a subpoena. And you need to ask them specifically, are you willing to say this in front of an administrative law judge under oath, knowing that your employer may still be on the line, may still be there listening in. So you know exactly what they're going to say at the time of the hearing, and not expecting that you know what they're going to say. Employers, first-hand witnesses are crucial. The big mistake for employers is bringing in witnesses that can only testify to hearsay. So employers should try to have available the person who witnessed the incident, whatever the incident is, and the first-hand witness, the person who was there. That is the most crucial witness, and most employers will have a personnel manager or a human resource manager, and they will testify from documents or testify based on statements given to them by other people who are not present. And of course, that's hearsay, and that creates a credibility issue. So the best evidence is first-hand knowledge, sworn testimony, first-hand from an eyewitness, and that goes for all parties. Representation, you may have a representative. You don't need to be a lawyer to be a representative in the unemployment appeal process. And employers often have non-lawyer representatives, and there are a few that actually represent claimants also. And you can represent yourself. 98% of these cases, neither party has a legal representative. Just be prepared. Get your stuff together before the hearing. Have the documents in front of you. Read the documents. Rehearse your presentation so you don't get tongue-tied. It's the 3 rules are preparation, preparation, preparation. That's how you should handle this case. Now, if you get a representative, make sure you give them a copy of the hearing notice. They need to have a copy of this, and remind them to read the instructions on the hearing notice and to look at the back side of the hearing notice. And tell your representative, or you call in and provide the name and contact info of the representative. But if you don't give the representative the hearing notice and you don't participate because the representative didn't know about the instructions, that's your problem. And you need to guard against that. Postponements and withdrawals, often, not often, but it does happen that people appeal cases that are in their favor. And if you appealed a case that was in your favor, you may withdraw. And you need to call the Appeals Bureau or send or fax a letter in. And make sure that you always reference the appeal number, social security number, name of the claimant. Or you can simply pick up the phone and call and ask to talk to your judge and tell them, I want to withdraw. If you want a postponement or a continuance of your hearing, think carefully on this, because asking for a continuance often results in lower participation. Doesn't really matter. There's 1,000 reasons why this happened, but continuances generally result in fewer people participating. Facts get old, documents get lost, witnesses disappear. So make sure you really need a continuance, because it does not go to your favor as a general rule. And I'm only talking about statistics. With respect to an in-person versus a telephone hearing, you have the right to have an in-person hearing. It will create a delay. Again, think real hard before you do an in-person hearing. Make sure you have really good reasons why you want to delay your telephone hearing, because if you ask for an in-person, it won't be on the same date and time. The judges are usually scheduled 1-hour hearings all day long, so they can't just change you to a in-person hearing. Many people feel there are just no advantages to an in-person versus a telephone. You need to consider it, and it's your decision to make. Now, the very last thing, and probably one of the most important and one of the most overlooked by claimants, is that if a claimant appeals a fact-finding decision and the claimant was denied benefits, the claimant must continue to call in those weekly claims. If there's a call-in and you find that the weekly claims you've been locked out for some reason, don't assume that it's because you received a losing fact-finding decision. Losing at the fact-finding doesn't lock your claim and prevent you from calling in your weekly job searches. You must continue. If you get locked out for some reason, it is not because you lost at fact-finding. You must continue to call in those weekly claims through the entire appeal process if you want to get paid the back weeks. That is probably the biggest error that claimants make, is they think that they lost. Now, there's one more thing before I conclude this video. If you are a claimant and you received a few weeks of benefits, and then the fact finder rules against you and you lose and denies your benefits, but you're back to work, you do have an incentive, a need to follow through on these appeal hearings, because you can get hit with an overpayment. So even though you're back to work, and even though the money's paid, and even and you won the first part, you need to follow through on the appeal hearing so that you don't get hit with an overpayment. Because if you lose at the appeal hearing, an overpayment will come out, and overpayments don't always come out within a few weeks. Sometimes it'll take a year or more before the overpayment is caught and in the notice issued. And overpayments stay on your record, and they can garnish your income tax, your state income tax refund. So overpayments are a serious matter. Don't ignore these appeal hearings just because you're back to work and no longer collecting benefits. Follow through on the issue. And that's about all I want to tell you for the unemployment hearing notice. Bottom line is, read the document carefully, both sides, read it twice, read it 3 times. If there's something you don't understand, call a workforce development representative and get help with it. If you need an interpreter, call in immediately and tell them you need an interpreter. If you can't understand any part of this process, there's always people to ask. There's no excuse for not asking. If you are expecting a call and the call doesn't come from the administrative law judge, don't wait more than 5 minutes. You must call within 5 minutes of the hearing time if you don't get your call. 5 minutes is it. These hearings don't start late. If they start late, you'll probably get notified. No matter what the procedure, 5 minutes is your rule on participation. That is all I want to tell you about this. The next series of videos